Good afternoon. My name is Yuval Shani, and I'll be moderating this online book launch. I'm very pleased to be with you to discuss this new book, The Occupation of Justice, the Supreme Court of Israel and the Occupied Territories, a second edition of a book. The second edition is authored by Professor David Kretzmer and Professor Yaël Ronen. These are, of course, not ordinary times in the region. These are times of fear, suffering, and violence. It is a time in which the normative frameworks that strive to serve as so-called gentle civilizers of nations, international law, morality, public opinion are put to an extreme test and fail more often than not to protect civilian victims. And we have considered whether it is appropriate in these circumstances to launch a new book. But we ultimately came to the conclusion that this specific book, which addresses the limits of laws and the limits of courts in the face of a long-standing conflict, which fluctuates between violent eruptions and other applications of power, which raises fundamental, if not intractable, problems surrounding the sharing of land and the collective rights and aspirations of people, is perhaps the one book for which an exception should be made. And indeed, many of the roots of the current conflagration, a sense of injustice, of dispossession, security threats, limited accountability, the failure of politics to resolve deep-seated problems are found in the present book. The authors of the book need little presentation in this venue. I'll note that Professor Kretzmer is one of Israel's leading authorities on human rights law in general and the application of international law in the occupied territories in particular, as well on the application of human rights in times of armed conflict and on the rights of the Arab minority in Israel. Dave has combined throughout his career rigorous academic work with human rights activism in Israel and beyond, and on the global front. He served for 8 years on the Human Rights Committee, which is responsible for overseeing the implementation of the International Covenant on Civil and Political Rights, and has been among the founding fathers and mothers of major Israeli NGOs, including the Association for Civil Rights in Israel, B'Tselem, and perhaps closer to home, he was one of the founders and the first academic director of the Minerva Center for Human Rights, which is organizing this event. Our second author, whose book we're launching, Professor Yaël Ronen, was part of the Israeli Foreign Service before joining academia. As an Israeli diplomat, she participated, among other things, in peace talks with the Palestinians. Yaël is a faculty in Sharei Mishpat College and a researcher at the Minerva Center, where she also serves as the academic editor of the Israel Law Review and as an academic advisor to the Hebrew University International Human Rights Law Clinic, and also as a research director in the International Law Forum, where she coordinates a digest of Israeli international law practices. Yaël has published extensively over the years on issues of human rights, conflicts over territory, responsibility of non-state actors for international wrongs, international dispute settlement, and other topics. There are two main types of second editions. One type of second editions of a book is essentially a similar book like the first edition with an additional update chapter or a new introduction. And then there are second editions, which are essentially a new book, which overhauls the first edition almost absolutely. And I think it's fair to say that this second edition is probably closer to the second model than to the first model. First, in terms of length, the first edition was published by State University of New York Press in 2002, and it had 10 chapters. It spanned over 272 pages. The second edition has been published by Oxford University Press. It has double the amount of chapters. It has 20 chapters, and it spans over double the amount of pages, 543 pages. In terms of the time period covered, the first edition dealt with the Supreme Court's involvement in cases relating to the occupied territories, up until the start of the Second Intifada in 2001. The second edition picks up from where the first edition ended and covers also major developments that have happened subsequently, including the Second Intifada, the separation barrier cases, which are probably the zenith point of the court's engagement with international law, involving what the court considers as its counterterrorism litigation. It also deals with the judicial ramifications of other dramatic developments, such as the disengagement from Gaza, and gradual developments that have happened in the last 20 years, which the authors consider to be a gradual process of transformation into settler colonial regime, where the laws of belligerent occupation play an increasingly or decreasingly marginal role with respect to some security measures. They do acknowledge, however, in this latter context, that perhaps recent decisions by the court, such as the Ziada case dealing with the evacuation of Amona, and the Silwad case dealing with the unconstitutionality of the regularization law, may suggest a late awakening by the court to the structural inequality that the situation on the ground perpetuates. They do suggest in this edition, and I think maybe that's the common thread between the two editions, that they do suggest in this edition, like in the first edition, that the court's role with respect to the occupied territories remains of a mixed nature in terms of their analysis, while providing justice in many individual cases and serving as a mitigating actor against extreme measures with harsh humanitarian consequences. The court also serves to legitimize, to some extent, the situation in the occupied territories for international constituency and probably more so for domestic constituency. They also criticize the court in the book for failing to enforce effectively key aspects of the laws of belligerent occupation, most dramatically with respect to the legality of Israeli settlements in the West Bank and house demolitions. Now, as indicated, the book has 10 new chapters. We do not have time to cover in these introductory remarks to cover them exhaustively. Perhaps I will mention briefly the new elements that the second edition contains. The first edition focused very much in terms of legal framework on the question of how international law generally and the Fourth Geneva Convention specifically have been applied by the court, noting in this context the myth of the benevolent occupation, something which something which has been completely lost out of the discourse in Israel and around the world concerning the occupation. The second edition adds rich new layers to the discussion and addresses the role of international human rights law in the court's litigation, the role of international constitutional law, and the implications of relating to Israeli settlers as part of the local population. This is an element which is also addressed in the second part of the book. And together, these developments reflect the response of the Supreme Court to the transformation of the situation on the ground, in which parts of large swaths of the territory are administered by Israel as if they were part of Israeli territory, with inter-community conflicts over land and other resources dominating the court's engagement with the situation. The second part of the book reflects the growing fragmentation of the territory in the post-Oslo disengagement years, perhaps reflecting an attempt to divide and rule the territory. There is a new chapter on Gaza post-2005, which is, of course, unfortunately extremely topical, dealing with the court's ambiguous approach to humanitarian responsibilities in this area. There are chapters dealing with the separation barrier and with planning and building in areas C, which are very interesting and important chapter. And the authors underscore in these cases, in these chapters, the role of the court as a linkage between national and international institutions. And also, they criticize the controversial use of certain legal fictions, such as the use of temporariness, in order to bridge the gap between the status quo provisions of the law of occupation and the changing reality on the ground. The third part of the book includes two new chapters, one on interrogations, which is a topic that remains a thorny issue for the court despite the 1999 decision, which appeared to have resolved this issue, but we know that it has not actually resolved the issue of use of harsh interrogation techniques. And then there is an important and interesting chapter on the review by the court of active hostilities, such as targeted killing and the use of Palestinian civilians arrest operations. One explanation that the authors provide for the court's involvement during time period with these cases is the concern about intervention by international bodies, including the ICC, which is again a very topical concerns. And here too, they mentioned the court also as a mediator between parties, between civil society and military, or as a harm mitigator, again highlighting the potential or the aspirational legitimizing role of the court. So of course, time is very short, and we have to now proceed to a very distinguished panel of speakers who would be invited to make their observations, to offer their observations about the book and the topic that it covers. We have a very interesting panel of speakers. I will introduce them very briefly in the interest of time. Our first distinguished speaker is Dorit Beinish, the former Chief Justice of the Supreme Court of Israel, also the former State Attorney of the State of Israel. Beyond her illustrious career on the bench and in the Ministry of Justice, in which Dorit has displayed on a number of occasions public courage in insisting to speak law to power, Dorit has also been teaching post-retirement comparative national security law and has a good perspective in comparing the work and the practice of the Supreme Court of Israel to other courts around the world. Our second speaker, Professor Yaël Benvenisti, is the Yaël Professor of International Law at the University of Cambridge and the director of the Laupa Center for International Law there. Yaël is also a member of the faculty here at Hebrew University of Jerusalem. He was a former director as well, academic director of the Minerva Center, and he's a world expert, one of the world's leading experts on the laws of belligerent occupation, as well as on human rights law and the use of international law by national courts. Our third speaker is advocate Daniel Reisner, who is a partner with Herzog Fox Neeman, one of the leading law firms in Israel, where he practices national security law and international law. In his previous life, Daniel was the head of the international law department at the IDF and was directly involved in some of the litigation discussed in the book. Daniel was also involved as a lawyer for the military in various peace negotiations and also in litigating national security cases in a variety of jurisdictions around the world, and also has extensive experience in teaching international law and dispute resolution in a variety of academic institutions in Israel. Last but not least, among our four speakers at the second stage of the meeting is Advocate Sausan Zaher, who's the Deputy Director General of Adala, probably the leading NGO working in Israel on Arab minority rights, as well as on other important civil matters occupying civil society in Israel. Sausan has litigated many important cases before the Supreme Court, including the Silwad case, which is probably the most recent. And no. constitutional and international law issues over the years, including social and economic issues and matters concerning the rights of women. So the way we are going to proceed, we are going to hear the 4 presentations by our distinguished speakers, and then the authors of the book will have some opportunity to react and to offer their own thoughts about the book and reaction to the interventions. And then we'll have time for a Q&A. We have a very large number of participants. We have more than 400 people who have registered. We are seeing that already more than 200 people have joined the meeting. So the way we're going to do it, I mean, those who would want to pose questions are invited to use the Q&A function. The Q&A function is available. Messages on the Q&A function are available to the speakers, to the panelists. They're not generally available to the full public. So we will see how much time we will have, but we will try to select a few questions from the Q&A box and present them to the speakers, either the authors or the commentators. Before moving to the authors, I just want to thank the Minerva Center team for putting this together, this impressive event, especially Darinov and Anat Mishali, who are responsible for the administrative dimensions of the meeting, and also Dani Evron, the executive director, and Einat Albin, the current academic director, for their support and advice. So I wish us all very interesting proceeding, and without further ado, I'm now turning the floor to Chief Justice Dorit Beinish.
Good evening. Thank you, Yuval, for your introduction. And really, it's a very special event, in my view, not an easy one. Usually, the defendant is not the first one to speak, but the last one to speak. Yet, you gave me the opportunity to be the first. Okay, I'll accept it. So, first of all, I want to express really my appreciation for this gigantic, I can say, work, the study done by really our best experienced professionals and academics on the realm of the law and the judicial review on the occupied territories, on the territories. I feel a bit, among professionals, specialists in international law, like you are all, and this is not my field, but actually, I mean, when I see Yuval and Alvin Benisti and Dave, it's not my field, it's yours. Yet I accompanied it and was involved, if I may say so, almost about 40 years. And in all these, in many of the cases that you mentioned in your book, that you analyzed in your book, and I saw and was close to the policy as the state attorney and later as a justice of the Supreme Court. So willingly or not, I was very much involved in those topics. Another personal comment is I think that Dave and me were years ago in the 80s appearing before the court on both sides. He represented the association, I think, of for civil rights. I represented the state. It wasn't that bad, Dave. We managed to do that somehow in the very difficult cases, and also negotiated very special problematic issues. Now, I must say, if we think about it, that we are now in the 54th year of what we call the belligerent occupation from the legal point of view. And this is a very strange situation because the laws, and again, you are the experts for belligerent occupation, are not really adjusted and to this situation that we are living in here for so many years. So I feel I must say, I'm at the end already saying that in spite of the criticisms that you have in the book, in spite of the analysis that many of your analysis, and comments, I accept, I must say, not that everything is not accepted. The background that you give is very, I mean, most of the background that you describe is the real background that we know. But at the end, when we come to your conclusions, I'll say that after all what you said against the involvement or the view or the way the court dealt with those issues, I really believe that no other court that I know in the world had to tackle with these issues and to stay and to do the work according to international law. I don't think that there are other domestic courts that applied international law, you know better than I, but I don't think so as far as I know, and did very much what is possible in an impossible situation, actually. When after 67, when there was a decision to apply the laws of belligerent occupation, I think that no one could foresee that it will last for such a long time. Even the political leaders thought that, I don't know, they had the model of 1956. They didn't think that this could last for, it was of course very serious political issues from the beginning. But when the court took the jurisdiction, because Attorney General that time, Shamgar, said he actually didn't raise the questions of justiciability, of the right of standing. It was for him and for those who decided on that policy an achievement that the court is recognized by everybody and even by people that were in the territories, and they had access to the court. And it started without giving actually any reason why it is possible. When we come to the end and the conclusion, I wasn't involved in 67, 68, of course, but when you think about it, you analyze it, we thought later it wasn't so clever, it was very important. I believe that the court had a great role in, as much as possible in this situation, implementing and applying the rule of law in the territories. And knowing therein from behind being at the state attorney's office and the state attorney, I can tell you that the court had an enormous influence on the decisions to mitigate. When you say at the end of your conclusions, the importance of mitigation, it is a very important factor in the role of the court. Now, it is true, I want to say, we have to think, what is the role of the court? It is a Supreme Court, first and last instance, no appeal, not a fact-finding court, and you mentioned the fact-finding. Relatively to other cases, the High Court of Justice tried later. We tried to do the fact-finding process, but the procedure is so different. And again, it is a unique situation. The Supreme Court has to look into all those matters. It is true, and I accept that it was much stronger when it is dealing with individual rights. Because this is actually the tools of a court. This is a practice of a court, not politics. We try to avoid politics. It is true that the court is a branch of government, in spite of the fact that this is an independent court, and for years an apolitical court, or tried to be apolitical. Of course, every justice has its own views, yet there was a real effort not to be political and to apply the law interpreted, of course, as Israelis. This is true when you talk about the interpretation of the Geneva Convention from the beginning. Now, when you are dealing with individual rights, this is actually the work of a court. This is what we know. Those are the tools that a court has, and much more than evaluating policies or interfering with policies. Not only because of, as you mentioned, the need of public support or public trust. This is not the only reason. Because those are really the practical, this is the work of a court. When you have a concrete case, it is for the court to deal with much easier and much more understandable than policies. And it is true that a court in every domestic court does not want to embarrass its state in the international field, I mean, in the political international field, international relations, every court is very careful about it. And actually, this court had the courage to tackle with issues that I don't know any other court. The Supreme Court of the United States thought that administrative detentions are not for the court because generals in Afghanistan decided this person is a very, very dangerous person, we will not touch it. Or methods of interrogation, not touch it. And we know that really awful practices were used. And the court never touched it because it's very, very difficult for a court. And our court tried to do that. Even in days of, we really had terrorist attacks, we had security concerns. It is true that the beginning was that everyone thought, I remember it like that, it's a temporary situation. Those are security needs that we have to support. The first settlements were under a cover, I must say, of security needs. And this, as the experts for the government said, this is the power of a military force that conquered the area to use. First, we try to say, and you bring this Bloom's theory, the state said that it is, you don't apply the Geneva Convention, the Fourth Geneva Convention, because the legal interpretation, it doesn't apply there, no one has the right for the territory, and Israel has a claim, all the story is known. Then it developed and changed, and we are talking about so many years, almost 5 decades, and the court has to adjust to the reality. You mentioned that the court didn't initiate. The court doesn't initiate. Issues that came to the court came because there were people who approached and came to the court. The court opened its doors to deal with it, which is not an easy decision. Now, as much as the time passed, it really became more administrative, you're right, administrative review, which is easier and familiar for the court than the international law. There is another thing I must say, the administrative law was the vehicle, the tools for the court to review military activities. Actually, they never gave, as much as I can say so, the reason, why is it for the court to have the jurisdiction? And Justice Landau then decided that the reason is because the military commanders, according to administrative law, have to obey to administrative law. And this is how he went into those topics, not through the international law. Although everybody, in our arguments, we also said that we have to respect the norms, the basic humanitarian norms of international law.
Dorit, can I ask you to conclude?
Yes, of course. So, as I said, I accept the idea that the most important role of the court was in mitigating harsh measures, in trying to, you say that actually, in applying administrative norms, in recognizing the duty to protect the population, what we call the protected population under international law. And at the end, I must say, and of course, there are the barrier, there are so many issues that you were referring to, and there is a lot to say about them, but I agree, I conclude in saying that still, in spite of the criticism, which part of it I even accept, I think that the court could not do better than what it did. And it's not, we are not talking about one case or the other, that could be a mistake. Not this is the question of the policy of the court. And as a policy of the court has done a very important, great work. Thank you.
Okay, thank you, Dorit. And we move on to Professor Yaël Ben-Venisti. Yaël, you have the floor.
Thank you very much. I would like to celebrate the book by presenting some of its key findings and observations. And so the first part of my talk will be summarizing some of the points made by the authors. The book examines the role of the Supreme Court in regard to the situation in the territories and related developments. It focuses on the court's willingness to contend with the scope of the military commander's powers in the occupied territories under international law. The authors identify 4 phenomena that stand out with regard to the manner in which the court has treated the tension between the political reality and the law of occupation. The first is the court's willingness to justify measures that are clearly intended to serve Israeli interests as beneficial to the local population. For that purpose, the second related phenomenon is the wide view that the court has taken of military needs, reasons of security, and public order issues, generally lumping them together. This enables the court, the authors say, to disregard the limits on the powers of the military commander under international law and to justify measures that are clearly intended to serve Israeli interests and involve restrictions on the individual liberties and rights of the local population. The third phenomenon is the court's adoption of the thesis that the welfare of the local residents is to be gauged solely in terms of economic development and material benefit, assuming that economic integration with Israel is good for the local population and they have no political desires. The fourth phenomenon is the inclusion of the Israeli settlers as part of the local population for whose benefit the military commander may exercise its powers. Now, in the context of the facilitation of the settlement project, the authors identify the key elements. And here are the elements. First, the refusal to recognize the applicability of Article 49, Section C of the Fourth Geneva Convention that prohibits the movement of the occupier's citizens into the occupied territories. The court said, no, it's not part of customary international law, so it's not directly applicable in Israeli law, and also that this is a political question, a matter for diplomacy. Second element, land. Settlements would be built on state lands, and state lands are under Article 55 of the Hague Regulation to be regulated by the military commander, and so can be allocated for the settlement project. The third element is the separate legal system for the settlers, ensuring that their legal environment will remain Israeli rather than part of the law in the occupied territory. So the court endorses the establishment of a separate legal system in the settlements. And then subjecting Palestinian interest to the needs of the settlers by including them as part of the equation of Article 43 of the Hague Regulation. There's also a sixth element, one that was covered extensively by our colleague Michael Kariani, focusing on the role of civil courts in Israel, extending civil jurisdiction and applying Israeli law based on choice of law rules whenever the litigants involve Israelis, even if the subject matter arises in the occupied territory. So here, a quote from the book: while Article 43 was meant to define the duties of the hostile army towards the local population in occupied territory, under the Israeli court's jurisprudence, it serves today to justify severe restrictions on the rights of that population in order to protect the security of other rights, security or other rights of Israeli settlers. And they conclude, after more than half a century of Israeli rule over the West Bank, the main function of the law of belligerent occupation has not been to restore and maintain public order and public life in the occupied territory. Its function is to provide a convenient and seemingly legitimate regime for control of the local Palestinian population. For the moment, focusing on the policy versus Gaza, these days it's important to note the court's willingness to accept policies set by the governments on movements into or through Israel from Gaza and to Gaza Strip. The authors show convincingly that the court is only prepared to examine whether an individual instance there are grounds to order the authorities to relax the policies. They are generally not prepared to balance the rights of the Gaza residents to freedom of movements or other rights, such as the right to education or medical care, against the Israeli interests in security. The proportionality test is not applied. It seems that the court's approach is that since such residents have no rights vis-a-vis the Israeli authorities, there is no place to examine whether such restrictions are proportionate or not. Now, the authors do acknowledge that the court is in a difficult position, as President Benish just stated. And they note, and I quote, the difficulty of a domestic court when faced with questions of international law that involve major political or security issues. Such a court is not a neutral actor. It is a state organ. It cannot side with international institutions that criticize the state's policies and define what are widely perceived as national interests without losing its legitimacy in the eyes of its immediate constituency, namely the domestic audience and political bodies. Indeed, I can attest to this, that this is the rule also with respect to other courts. Here's my personal story. When I worked on my doctoral project on the law of occupation, in the lower basement of the law library of the Yaël Law School, I remember the moment in which I lost my theoretical naivete and became a legal realist. I was sifting through the case law of national courts related to the law of occupation, German courts, Dutch courts, Italian courts. There was then a moment where I realized that there was only one logic to the jurisprudence of national courts dealing with occupation law. The judgment invariably reflected the state interest, regardless what the law said. They were bending it, twisting it, distorting it, and reaching all the same outcome. We say what our government wishes us to say. And it came quite early on, starting with World War I cases. I remember reading a German court that authorized the spoliation and plundering of Belgian assets during the German occupation of Belgium in the name of the law of occupation. And immediately after being occupied in 1918, refusing to accept the validity of acts of the French occupier of the Rhineland. So what can we conclude of that? That we cannot trust national courts, that they should remain silent during war, as Chief Justice Rehnquist once suggested? I don't think so. I think that the heroic failure of the Israeli court, so closely analyzed by this book, helped to maintain the temporary nature of the occupation, and that the idea that everything or almost everything is reversible. And the courts and the authors note this point, and they say, if one wishes to find a mitigating factor for the court jurisprudence on the issue of settlements, the court will provide legal backing to a government decision to evacuate settlements, whether under a political agreement or unilateral political decision. If there is one element that keeps the law of occupation alive in Israel, and indeed globally, it is its consistent misinterpretation and misapplication by the court. What would have happened if the court would have resisted? Perhaps the outcome might have been the direct extension of Israeli law. So arguably, the insistence to continue to misinterpret the law is valuable in and of itself for international law in general. National courts that distort the law of occupation generate searing scholarship like this book, and the scholarship arouses debates like the one that we are having today. Without the consistent misinterpretation and misapplication of the law, the resistance would have never been so clear and so sharp like these books. And the law of occupation would have probably have perished, like other bodies of international law that have become desuetude over the years. To keep this crucial doctrine alive, we need rigorous and comprehensive books by fearless scholars that help maintaining the temporary nature of occupation. So I wish to end my remarks with simple words of thanks to the two authors. Thank you very much.
Thank you very much, Yaël. We move on to the third speaker, Advocate Daniel Reisner. Daniel, you have the floor.
Thank you very much, Yuval, and congratulations, Dave and Yaël. A magnificent tour de force of a difficult subject, unfortunately very timely as well. When I read the book, and I finished reading it just today, I have to say I finished reading it with a feeling of sadness. And I want to reflect that sadness because I read the book from 4 different perspectives. The first perspective was of a former military lawyer for 20 years. And during those 20 years, I was responsible for many of the cases in the book. And Dorit and I spent hundreds of hours on some of those cases, and some of the stories are in the book, and most of them no one will ever know. My second perspective is that of a peace negotiator for also 20 years. And Yuval, I wasn't just a peace negotiator for the army, I actually was the lawyer for the peace process for Rabin, Peres, the 3 Netanyahus, 1, 2, and 3, Ariel Sharon, and even for Olmert. And I spent 20 years of my life trying to help reach an agreement with the Palestinians, and unfortunately I failed. The only thing I can say in my defense is we gave it our best shot several times, and that in other cases, such as the Jordanian Treaty of Peace, we were more successful. So for that, I'm still proud. The third perspective I looked at the book was as an international lawyer. I've been working in this field. I am now I actually checked my math. It's 36 years. So it's a long time, and it does give me some perspective. And the final perspective, as a citizen of the state of Israel, currently with 2 sons in the army. And those 4 perspectives each read the book differently. And I want to share with you the 4 different perspectives of the book from my perspective. And I want to highlight some elements of the book from each one of these. I'll start from the military lawyer side. Some of the most infamous or famous, depending on your perspective, cases in the book, I know quite well. I'll take all of the house demolition cases, the famous deportation of the Hamas and Islamic Jihad, the targeted killing case, all of those cases were mine. And many of the legal theories presented by the government in those cases were mine. And I say that because having read the book, I think the book accurately reflects the story and the dilemma and the problem in all of those stories. So thank you for that. That was an accurate portrayal. I want to share 2 quick anecdotes to put things in a slightly personal perspective. When we look at house demolitions, I was probably the longest serving person in Israel dealing with house demolitions. I did it for 20 years. I started as a young lawyer, and when I retired, I was still doing it. And I personally reviewed hundreds of cases of house demolitions, and not only those that went to the Supreme Court, also the cases which never went to the Supreme Court. And one of the things I suddenly realized, it was about 2000 and it was around 2000, that I was starting to see something which scared me. You see, I could show evidence, and I'm now addressing a specific chapter in the book, that house demolitions were effective. I'd seen it with my own eyes in dozens of cases, but they were always effective in the short term. The problem was I was starting to see new cases coming to my desk of new terrorists, a new generation of terrorists, who in their interviews would say that the reason they became terrorists was because their family's house was demolished. And when I saw the 3rd and 4th and 5th and 6th case of that nature, I suddenly said, wait a minute, I may be the only one seeing this long-term damage. And so I started looking at it more carefully. And after reviewing it very carefully, this was, I don't remember the exact year, I went to my boss, the military advocate general, and I convinced him that we send a letter together to the chief of staff saying that while there is short-term benefit, I believe that there is a long-term strategic inherent danger in house demolitions, which counterbalances that. And therefore we recommend, not as a question of law, but as a question of policy, that you reevaluate the logic of using house demolitions. This was in 2000. The only problem was that 2001, and then we had 2002, and we had the attack in Netanya, the suicide bombers, and our letter was lost in the events, and later would be rekindled by a committee, the Shani Committee, the other Shani Committee, in 2005. So to end the house demolitions anecdote, I remember a chance meeting with a Supreme Court judge whose name I will not mention. I will also not say if it was he or her. And that judge took me aside and said, why don't you stop demolishing houses? To which I responded, why don't you stop approving them every time it comes to court? So I wanted to share with you that the dilemma about house demolitions, for example, is not just in the courtroom, it's not just in academia. The same dilemma existed and exists within the security services. But that is, of course, outside the scope of the book, but these questions are asked. The second anecdote, Dorit, is the deportations case. And this is a case which exemplifies for me the dilemma in all of its intricacies. When Ehud Barak came up with the idea of deporting hundreds of Palestinian leaders to Lebanon, he said this would be the solution to the second intifada. And because Ehud Barak is a genius, and he is a genius, everyone said he must be right. Now, when he said that, 2 lawyers in the Ministry of Justice Dorit and Nili Arad, refused to represent the government in that case before the court. And the government was found itself before the petition without a lawyer from the Ministry of Justice to defend its case. Barak called me and said, you will appear in court. I was a major in the army at that time and defend the case. And I said, no, I won't. And he said, why not? And I said, because if you send a military lawyer into the Supreme Court to defend this case, the judges will immediately understand that none of the civilian lawyers would have represented. And then you've lost the case from immediately, and justifiably so. At the end of the day, the Attorney General of the State of Israel volunteered to take up the case, and he represented the case. I sat next to him through the case. And this was a horrible case to sit through. Because if you remember, Ehud Barak came in and was, for the first time in my experience, and I think the last time ever in a Supreme Court case, he was cross-examined by Leah Tzemel in the court. And he actually gave a speech saying, this is a solution to the Second Intifada. Trust me, I know what I'm doing. And I could see all the judges of the Supreme Court saying, what do we do now? Are we going to say that we won't solve the Second Intifada? And this placed the court in an absolutely impossible situation. And you could see it happening as we were there. Now, I say this because one of the things that the book mentions in passing but does not focus on, I think for justifiable reasons, is the huge impact of the court inside the military without court cases. The number of times I use the word, this will not succeed through the court, to stop an idea in the army cannot be counted. You call this the shadow of the court in the book. The shadow of the court is extremely long. So much for my military lawyer perspective. For my peace negotiator career, 20 years of my life, I can say that when I negotiated with the Palestinians, we were really hopeful that we would finish the negotiations by the year 2000. And of course, that did not happen. But the entire focus of all our work was that everything that is in the territories now is temporary. And I'm sorry to say that that may no longer be true. And unfortunately, that was one of the justifications that we gave ourselves for many of the things that we wanted to do. So the reality is that if we come to the conclusion that it is no longer temporary for reasons perhaps outside our control, we need to rethink the question, okay, so what do we do now? Because a lot of the things we built were built around the premise of temporariness, as Yaël said. The third perspective is as an international lawyer, and here I have a short criticism of the book. Reading the book, you make international law sound very clear and very easy and very simple. I don't share that perspective of international law, not the international law of belligerent occupation or of armed conflict. The rules are ambiguous. The question marks are much bigger than the exclamation marks. And on many of the issues where you claim international law says something, I know of other opinions, including mine on some of the issues, where other people say other things. And I'm sorry to say that the book did not reflect other opinions sufficiently, in my view. It presents a slightly too uniform perspective of what you think international law says. Now, I have to admit, I think you represented well the world's majority opinion on many of the issues. I'm not saying you didn't do that. But I think a book in Israel would have done well to at least represent the fact that there are people, including international lawyers, who have different positions on some of these issues, which are run to the core of some of the questions that we are discussing. And the final perspective is a citizen of the State of Israel. And I wanted to say here a few short things. First of all, I was sad, and I have 1 minute.
Very short, Daniel, okay?
1 minute. First, I was sad to see the reflection of the impossible situation in which we place the Supreme Court on dozens of occasions. At the same time, I am extremely proud of the court for all the good it has done over the years, and it has done an immense amount of good, and I've seen it firsthand. And third, and this is actually my final point, I think we need to discuss what the role of the court is. In a country of our nature, where we have three pillars of society, of legality, the court, the parliament, and the government, we should not expect the court to overrule and override the government and the parliament as a matter of course. That is not its function. They need to balance one another. But an expectation that in the name of the law, the court can go to the government, the parliament, and the people and say, we know better, because the law, which was written by man, not by God, says something else, is an unrealistic and, in my eyes, wrong expectation. So the bottom line for me is that I think the court did what it could, but in many respects, I think it did what is expected of it in the complicated Israeli reality. And for me, the excellent mirror that you have presented in this book, for me, I can see the glass half full more than the glass half empty. Thank you very much.
Thank you, Daniel. And the fourth and final speaker in this part is Sausan, Advocate Sausan Zar. And thank you again, Sausan, for joining us. I know this is a very busy time. Your NGO is swamped with work and the current troubles that we are facing. You have the floor, Sausan.
Yeah, good evening, everyone, and a big mabruk for the very important book. Big congratulations, basically this is it. I would like to basically try to put some reflections, short reflections and short observations about an important question that we in civil society mainly are posing now due to the decisions of the Supreme Court regarding the occupied Palestinian territory. Having 54 years of court decisions, which basically, like the book referred to and detailed, had give also legitimacy to the occupation, to a prolonged occupation, not only giving legitimacy to the establishment of settlements and the transfer of local population to the occupied territory, but also when we look as well at the court decisions regarding things that are very more basic on a day-to-day life, like establishing roads and their usage by the settlers, like exploiting natural resources by Israel as an occupying state, which all were legitimized and justified by the state in different ways, but including by the fact or by the reasoning that even if changes would be done, even if they are for the purpose of the local population and they are done for permanent a term or long term, the court did legitimize them. And this poses a huge question about, of course, the legality of the occupation, being it a prolonged occupation. Now, the question or the situation that we are now, after all these years of the Supreme Court decisions, put us as civil society, and I think as well, of course, as academia, in a situation that we have to ask, what is next? What is next in terms of the conversation? If the Israeli Supreme Court has basically refused in one way or another in its own reasoning to basically rule in the legality of the occupation, then can we as civil society basically continue with submitting with our litigation, with our arguments, if it's basically been blocked by the reasoning and the court rulings at the Supreme Court? And what has been happening in the past year or two is very, very interesting, because there has been a shift of shifting the questions from the legality or actually the illegality of the occupation on a legal level, in legal terms and legal analysis, to the question of should the situation be called in different terms. should we start referring to the legal system or to the legal situation in terms of the crime of apartheid? Should we start checking whether we can define the whole Israeli legal system as an apartheid regime, not necessarily based on the definition of the crime apartheid as a war crime, but as a legal system that basically serves both sides of the green line, despite the differences in the laws that are applying on both places. And this discussion has been basically ongoing in a very lively way in the past year and a half or 2 years among civil society, whether Israelis or Palestinians in both sides of the green line. Some organizations like Yesh Din had concluded that, and issued, of course, a paper last summer, that the crime of apartheid does exist, however, only in the occupied territories with the analysis that they did. Other organizations like B'Tselem in early January issued a different point of view, where they defined basically the regime as a regime of apartheid based on the definition in international law. And the discussion or the debate is very important, not only in the terms of the blocking of the discussion of the legality of the occupation or the illegality of the occupation by the Supreme Court, because it did refuse to discuss it and to rule on it, but it also is important because of the question of the remedy that you would ask for in the different ways that you are defining the system. If we're still gonna continue debating about the illegality of occupation as civil society, demanding the end of the occupation, which we know that this will not happen in the Israeli Supreme Court, what kind of remedies would we have as a human rights organization if we will move to a formal definition of apartheid? Now, of course, this still poses a lot of question, because one of the remedies, and we know that well from apartheid South Africa, is that ending apartheid mainly comes through the demand of equality. One man, one vote. Now, if this would be the demand, can it be implemented in the circumstances of the occupied territories? Another question that rises, how would it affect as well the status of the Arab Palestinian citizens inside of Israel? Because following the report of B'Tselem, which looked at the situation in a holistic view and claimed that the legal system or the regime is apartheid, as you all know, or most of you know, that Human Rights Watch also issued their own report, and this report didn't come by coincidence. It came because of the prolonged occupation. It came because of the rulings of the Supreme Court in the last 54 years and the refusal to deal with the most important question of the legality of the occupation. Now, I think that also the report of Human Rights Watch and B'Tselem again raises a lot of questions, because if we want to look at it in a very holistic way, I think that the questions rise mainly not only for the remedy of what should happen in order to end such regimes, or whether such definitions are enough, whether colonial regime is the definition, or whether settler colonialism is the definition, and can we apply them on both sides of the green line? And these are questions that are not easy, of course, as you all know, in the academia. Neither are they for us, because they would reflect on how we would present our arguments in the Supreme Court in the petitions that we bring. One of the most difficulties that we're facing, or questions that we are raising, is that if we will have to look at the situation in a holistic point of view, defining it, whether defining it as apartheid, as colonialism, as settler colonialism, how would this affect us as a national home minority Palestinians inside of Israel in terms of our political demands and not only for our legal demands. Now, these questions as well are also like, despite the fact that they came out of Israeli organizations like Yesh Din and B'Tselem, and now international organizations like Human Rights Watch and forthcoming as well Amnesty International. But it's also important to reflect on the most recent decision by the Third Committee, the Convention on the Committee, which is responsible on implementing the Convention on eliminating all kinds of racial discrimination, which towards the end of 2019 issued for the first time concluding observation, basically reflecting on racial segregation against Palestinians by the Israeli authorities on both sides of the Green Line. This was a decision that we never seen before. This was a decision that we saw as a victory in civil society. But this is also a decision that raised as well and still raises a lot of question, especially in light of having the Jewish nation state basic law. Now, this is also an important thing because how would the Supreme Court in Israel deal with the Jewish nation state law, and whether it would as well apply based at least on Adala's arguments in our petition, not only constitutional law, but international law and international humanitarian law, knowing that the Jewish nation state law, which imposes a constitutional identity also on East Jerusalem, which is regarded as an occupied territory, also based on the ICJ decision and also based on the recent ICC prosecutors' decision to examine war crimes, including in East Jerusalem. So the question is, how would the Supreme Court as well rule or deal with the issue or with the constitutionality of the Jewish nation state law, whether it will refuse to do so, because so far since December, when the first hearing was held before a wider branch, we still didn't get an order nisi, and last month we had to submit a motion to issue an order nisi, because otherwise for us this means the dismissal of the petition. And what would that mean in terms of applying the Jewish nation state basic law, not only on Palestinian citizens of Israel, but also on East Jerusalem, with all the questions that rises with the exclusive implementation of the right to self-determination for Jews only, and giving legitimacy as well to discrimination rather than equality.
So Sam, can I ask you to move to closing, because we're running out of time. Thank you.
Yes. Now, I think, I will conclude just in 1.5 minutes. And I think that the shift that also Yuval, you mentioned in your introduction, having the newest cases, especially in Silwad, where the Israeli Supreme Court as well did dismiss the regular settlement law, but still one of the reasoning was based on the argument of equality. Now, not discrimination, not having differentiated or distincted between a local population but based on IHL and settlers, as well based on IHL and the hierarchy between them, but rather, among other things, on the right of equality, saying and ruling basically that in a regular administrative level of examining how the right to equality was violated, that there was no distinct differentiation between the two groups that are living on that territory, and thus basically saying that there is no difference, that settlers and the Palestinian local population is being seen by the Supreme Court as one equal group. Now, I think that instead of going and continuing or making a shift by the Israeli Supreme Court to examine the legality after 54 years of court decision and prolonged occupation, I think that the shift now in Silwad and in Ziyadeh is very, very worrying, because it is going to a discourse of human rights, using the right to equality, examining it on an administrative level. I don't think that there are a lot of answers to all the questions that I posed. These are questions that genuinely are making us busy, and not only in Adala, but all civil society, but they are worth being taken, because the shift and the discourse and the conversation indeed must change. Thank you.
Thank you, Sausan, and I want to thank all four speakers for raising a lot of interesting, at times difficult questions and observations. And now I want to turn to the two authors, to Professor Kretzmer and Professor Ronen, to offer some of their remarks about the book and about the interventions that we have just heard. So I turn to you first, Dave, to start.
Okay, thank you very much. And I want to thank Yuval and all the panelists for taking part in this discussion. And I'd like to start with a special word to Chief Justice Benish. She mentioned that we appeared on the other side of the arguments in a number of cases. And I must say that it was very important to me that on the other side there was Dorit Benish, because I knew that there was a lawyer of total integrity and had a tremendous commitment to the rule of law, which he proved time and time again, especially by a courageous decision mentioned by Daniel Reisner, that in certain cases, in spite of tremendous political pressure, she would not defend certain actions of the government before the Supreme Court. So I want to thank you now before this audience for all that you have done. But I want to now refer to your remarks, and let us start with the first thing. Would any other court have done better? No, given what Yaël said, probably not. But we were not looking in a comparative perspective. We were not judging the Supreme Court against other courts and saying, look, other courts would have done better. I have no illusions, and we set it out in the conclusions about the kind of constraints on domestic courts. Those are not constraints specific to the Israeli Supreme Court. Possibly the Israeli Supreme Court in many cases did far better than other courts would have done in similar circumstances. So you ask, could the court have done better? Well, I have to judge this from 2 points of view. And this is reflected in our conclusions. If I look at it from a political science point of view, and if you want from a sociological point of view, probably the answer would be no. You're expecting too much of the courts. They did as much as they could. And in some of the cases, even a recent case dealing with allegations of torture, one of the justices more or less conceded, look, we've done as much as we can. We can't go further than we can. However, we do have law. And it seems to me that as lawyers, even if we can recognize the political constraints of the court, we can point out where we think that the court took a path which is not compatible with the law, and that is what we try to do in many cases. Now, Daniel Reisner criticizes us by saying, well, you took a very partial view of international law. Now, I accept that the law of belligerent occupation is what Yaël Gross has called indeterminate. It's not all the rules are totally clear, but there are certain instances where the law is totally clear. And it is in these instances where the court failed. And the major example is the question of Article 49(1) of the Geneva Convention, which outlaws deportation of protected persons from occupied territory, whatever, no matter what the motive is. There is nobody, I think, who really could accept the kind of controversial and self-serving interpretation adopted by the majority of the courts in the case in which Daniel was sitting behind me and I, together with Avigdor Feldman, was arguing the case. So here you have a case where the law was 100% clear, and yet the court ruled otherwise. It's our considered opinion, and that is the opinion of the vast majority of legal commentators. We cited people who have a different view, that is the same as far as punitive house demolitions go. Now, Daniel says, well, okay, we took a policy view, but the question here is not only a question of policy. The question here is first and foremost a question of law. And it seems to me that the court, first of all, ignored most of the legal arguments relating to the legality of this measure. And when it dealt with them in a totally inadequate fashion. Now, having said that, could the court have done any better? Clearly, the court has a mitigating role. And we write in the conclusion that mitigating role is felt in many levels. Number one, because in some cases, the court does give a remedy. In other cases, more cases, the court more or less negotiates a remedy. In even more cases, the authorities, because of the petition, step down. And I quite accept what Daniel says. In many cases, probably the lawyer said, listen, you can't do this because it won't stand up in court. That is exactly the situation, and we don't have any argument with that. The problem is, and that Doreen Bainish mentioned this, nobody in 1967 thought that the occupation would go on for over 50 years. But it has. And we are now faced with this situation. And we are faced with a situation where the people in the occupied territories do not have political rights. And the only possible protection they could have, at least from the authorities in the state, which has effective control of their lives, is legal protection. And therefore, one has to look at the jurisprudence of the court in that light. I do not accept what Daniel says, well, we have matters of policy, and the court doesn't get into matters of policy. When I look at other facets of the court's jurisprudence, suddenly the questions that the court doesn't deal with policy fall aside. Let us take the major example of the conscription of yeshiva students, a queer question of a political policy, a political arrangement, and yet the court, mistakenly in my mind, but the court was prepared to deal with this, although it didn't really have an effect on individual rights. And yet many of the government policies, most of the government policies, if you take the policy as far as Gaza goes, it has a direct influence on the rights of individuals. Now, the one question, of course, is the question of the settlements. And here I fundamentally accept that although the court legitimized the settlements in various mechanisms, even though it refused to rule on their legality under Article 49, paragraph 6 of the Geneva Convention, I do not know what would have happened if the court would have ruled, sorry, all settlements in the occupied territories are unlawful. It seems highly doubtful in my mind, and we're talking about the late 1970s, the beginning of the 1980s, when I had a government which was totally committed to settlement of Jews in the West Bank and in Gaza. It is highly unlikely that this would have changed government policy. I don't know what the government would have done, but it clearly would have found a way either to restrict the jurisdiction of the court, to try to change the law, or possibly, and we've had some cases like that, simply to ignore what the court has said. And so the situation is complicated. We have tried to give a fair picture of the court. In the end result, I must make it quite clear, although at the end of the book, we say quite clearly the court has mitigated policies. It has enabled a large number of Palestinians to receive a remedy which they would not have had if there were no judicial review. But on the other hand, it has not guaranteed the rule of law in the occupied territories. Does this mean that the court should have kept out of the issue? No, I accept Yaël Ben-Benishti's analysis. The very jurisdiction of the court, the fact that it was prepared to engage with the law of belligerent occupation. I have a different view from Sasan about the judgment of the court in the Silwan case dealing with the law passed in the Knesset to regulate so-called unlawful settlements. I think that that was a very, very important decision of the court, which showed a change in the direction of the court and more willingness to give active protection to people in the occupied territories. So, I mean, these questions are open. We're waiting for the counter book. And I want to thank you very much, all of you, for participating. I apologize to you all if I haven't related to all your questions, but Yaël now has the floor and she will relate to some of the other questions.
If not Yaël, then in the third edition, we'll get all the answers. Yaël.
Okay, well, so thank you all. First of all, thank you to the speakers for honoring us with your participation, and for the Minerva Center for organizing this event, and of course to all the attendees for still being with us at this stage. It's interesting because I think most of my comments go to the same issues that Dave addressed, although with a slightly different angle. And I think I'll do it in order of speakers. So first of all, thank you for the kind words and for the compliments. Thank you also for the criticism, which is part of the package. So one issue that I wanted to raise with respect to President Beynish's words about the fact that the judges at the early stages did not know that the occupation was going to last for such a long period of time. And by implication, and I think implicit in that was that had they known that, maybe they'd have taken different decisions, or but definitely I think we need to make it clear that we're not judging the court's decision of the past based on what we know today. That would obviously be unfair. But I think if we can only judge the decisions based on the facts and on the situation that the court had before it at the time that those decisions were given. And yet I think there are decisions that could have been and ought to have been different at the time that they were given. And as Dave said, how deportation is one issue, and house demolitions is another, where the court could have taken a different route, even on the basis of what it had, and the length of the occupation may not have been the most relevant issue then. There are issues on which the court would not have been able to adopt a different decision, whether in the past or in the present. And again, as Dave said, the settlement policy, would it have made any difference? What would that have been? What would have been the effect of such a discussing the legality of the settlements, let alone what the decision is? Would that have changed anything? Likely not. And then there's those issues where they may not have known then what we know today. For example, decisions relating to the status of Israelis. Deciding that they should be regarded as part of the population in the early days was one thing. I'm not sure that in 1971, the court could envisage what regarding them as part of the population would mean later on. The same thing could be said with regard to issues on residence and family reunification of Palestinians, that the situation in 1969 or 1971 is very different from the one we have today, and the court could not know that. But then there's decision that the court issues that the court has been engaged with in recent years, where it already knows what the situation is, and yet the question is, so why are those decisions really inevitable? I think the most important one is the willingness, the acquiescence with the existence of different systems of law for Israelis and Palestinians. Now, it didn't exactly start now, but today we know what the implications are. And yes, the court could adopt different decisions on specific discrete issues, but those discrete issues sometimes make up the big picture. So this is on the issue of what they knew then and what they know now. With regard to what Yaël said about the importance of insisting on the application of the law of occupation, I just wonder whether you're not overly optimistic in the sense that if today and basically still insisting on the law of occupation in the court is what holds annexation at bay. like you said, the extension of Israeli law. And I'm just wondering whether the way that the court is applying the law of occupation does not effectively enable annexation. And then the outcome is that under the law of occupation, everything would be regarded as legitimate. So now, do I have an alternative to that? No. And this, I'll refer to that in a little while about the privilege that we have of not having to offer any solutions. Something that, a couple of things that Daniel said. One is that we didn't pay enough attention or give enough weight to the shadow of the court. And I think, just as Dave said, that this is not a comparative study, and therefore we're not making a comparison, like the issue of comparison with other courts was not an issue because this is not a comparative study. Where this is also two things. One is, what we're interested is what is the legacy of the court's jurisprudence. And when things happen in the shadow of the court, they do not become part of the law. Now, we're not disregarding the importance of what happens in that shadow, but if you're looking at what is the law of occupation, or what is the law applicable to the occupied territories, what happens in the shadow of the court is just simply not there. So we acknowledge it in terms of this is where individuals get their remedy, mostly in the shadow of the court. I think perhaps the place where this is most visible is if we're looking at cases against various segments of the separation barrier. There's, I think, 7 court decisions that require the state to amend the route. 7 out of, I think, almost 200 petitions. But that's not, it's not only 7 cases where the route was changed. There were other cases where changes were made. They just never got to a court decision. That's the shadow of the court. So it's extremely important. It just does not create law. The other thing is, you said about how law is not that determinate. International law is not that determinate. And Dave referred to, well, if you look at the law on the prohibition on deportation, that's very clear. I'm guessing that what you were referring to was the question of, are the territories occupied to begin with, whether this is the correct legal paradigm that we should be dealing with. Well, here, again, in the same way that this is not a comparative analysis, it's also not a book about international law. And therefore, for our purposes, and we do deal with the issue, and you're right, we give great weight to the broadly accepted position that the territories are occupied. But the main point for our purposes is that the state and the court, I mean, the state as in the government and the court, accept that the law of occupation, whether it be the Hague regulations or the Geneva Conventions, apply. If it were not for the law of occupation, private property could not be taken for various purposes. The court justifies certain measures by their legitimacy or legality under the Geneva Convention. So, this is one answer. We're accepting, we're playing according to the same rules that the court has set, and our point is that the court does not stick to its own rules. The other thing is that I think you're right. I'm almost done. Yeah, okay. The other thing is that you're right. There is not enough engagement with international law and its meaning. I would say that that's part of the problem, that the court easily glosses over international law and skips over to other issues, and it could engage more with those questions. Who knows what the answers would be? I know right now we know that the answers are indeed always what the state wants, the state gets. Whether international law would mitigate that, we've yet to see. Finally, with regard to what Salson said, and this is where we have the privilege of not having to make operative decisions. So, the question of should civil society address the issue in terms of illegality of occupation or in terms of apartheid or in terms of colonialism? Far be it for me to give advice to anybody who actually has to litigate in court, but I think what comes out of the book is the court is not the place to expect any change. As you say, the court is not going to decide is not going to declare the occupation illegal. It's also not likely to determine that Israel is an apartheid state. It's also not likely to decide that there's settler colonialism. And if it comes to the nation state law, the chances that it would examine this law in accordance with international law when Israeli constitutional law does not provide enough tools are also slim. And by the way, and this is digressing, I think constitutional law might basically offers the same things that international law does. So just to conclude, I think that the discussion here is very much in terms of apology for the courts or censure. And we're not trying to grade the courts. As Daniel said, there's a glass half full, half empty, and we each tend to see the half that fits in with our worldview. I think what we tried to convey was that there are, in fact, that there is water in the glass, but it's not full. Whatever one considers the water to be and the empty bit to be, it's complicated. And I think the debate very much in Israel tends to be in terms of, does the court legitimize the occupation, or does the court stop the government from carrying out its policies and block the government? It does both. So again, thank you all very much.
Okay, thank you, Yael and Dave, and I want to thank the four presenters, the four discussants. We will take, we're already out of time in terms of the scheduled program, but we will take a few more minutes, very briefly. We'll go maybe 10 more minutes with your indulgence to answer. We have many questions. It's not possible to address all of them, but maybe I will just read a few questions from the Q&A segment, and I will allow any of the speakers who want to come in either to react to other speakers or to deal with the questions. So some of the questions, again, and apologies to those who I'm not able to represent because of time. Some of the questions were in the direction of what if. So I think you've already addressed the question of what if the court had proclaimed the settlements illegal from the beginning. But there are also questions about what would have happened had there been no standing for Palestinians to begin with. How would that have affected the situation on the ground? And I think there is a future going question as to what would happen if the Knesset would pass an override clause, would change the way that the Supreme Court addresses cases relating to the territories. There is also a question about the court's engagement, both with claims relating discrimination amounting to apartheid. The court in the past was very hostile to this line of argument, and there is the question whether this is still the case in light of the general consensus that we have had here that the situation is anything but temporary. And to whether the court's rulings on issues like the boycott law or the have generated a climate in which it is more difficult for civil society to operate in Israel. And finally, perhaps maybe the question of what can be done in order to change the dynamic and basically try to move forward on this in this very lengthy stalemate. So maybe I will now turn in reverse order to the speakers, and then I will give the final words to Dave and Yael. So maybe San, if you want to respond to any of the arguments, and then we'll go Daniel, Eyal, and Dorit, and then I'll give the authors. So Dorit, you will not be, so this time the defendant will have maybe not the last word, but almost the last word.
Yeah, briefly to respond, I think that my intervention was about the description rather than what arguments to bring before the Israeli court, knowing that the Supreme Court has, we have limits. We know our limits in the Supreme Court, but we also know the general, more constitutional and political atmosphere that we are litigating as a human rights organization, not only us, but all human rights organizations. So if the description of regime of apartheid or colonialism, of course, it's not something that, or actually, you know, it needs to be discussed. It's not something that, yalla, let's go argue. But we did start arguing in the Jewish nation state petition that we submitted, that the Jewish nation state law does create a regime of colonialism with future characteristics of apartheid. Now, how will this influence the litigation? That's something else. That's an interesting question. I think that the ramification of the decision of the court when it will issue will have a lot of ramification, because it will affect the issue of the status of the right to equality and the principle of discrimination. Now, what would have happened if there was no standing? Interesting question. Maybe the baby would have been called by its name already from the beginning. But I do think that throughout the years, human rights organizations did consider at some points not to bring petitions to the Supreme Court. This did happen on the Gaza war in 2014. If you pay attention, no petition was submitted back then because we knew the result. Also, we didn't want to have more damage to the court decision that we already had. Yeah, that's it. To make it brief. I'm done.
Okay, thank you. We really have to be now very concise. Yes, Daniel.
I will try to be very concise, Yuval. 2 short points. Point number 1, the expectation that the Israeli Supreme Court will rule on issues of national policy is unrealistic. It's not the yeshiva bucher enlisting into the army. That is 2 orders of magnitude below the question of the legality of the settlements and the status of the West Bank. These issues run to the core of the divide in Israeli society today, and it is quite obvious that most of the international lawyers belong to one side of that equation. However, the state of Israel, the people are not necessarily in the same place, and expecting the court to take the position of one party, which could be a minority, which could be right, if my opinion was heard, is not a realistic expectation in a country which wants to survive. And therefore, expecting the court to solve the country's problems when the political leadership cannot solve it, I think is unrealistic. The second comment, I think we should look forward. And the real question is, where will the Supreme Court go next? Because in spite of the music of this book, the reality is the court is under extreme pressure from the other direction. So they are being blamed for being too pro-international law and too pro-peace and too pro-whatever. And while this book does push back in some respects, it doesn't change the fact that everyone now thinks the court isn't doing its job, which for me is a horrible result, because I always think of how would we look without the Supreme Court of the State of Israel, without the court willing to intervene in matters which no other court in other Western countries has agreed to intervene. So as I said before, I am happy that at least we have what we have, but I'm very sensitive to the fact that if we push too hard in any direction, we could destroy the very system that we want to preserve.
Thank you, Daniel. Yaël?
Yes, thank you. 2 quick points. To Daniel, your position about the fact that the law is unclear, this is your consistent approach to IHL. In general, it reminds me of Samuel Amoin's new book, Humane. I just read it yesterday, and he argues that the US position with respect to the codification of Additional Protocol 1 during the 1970s, they were in support of AP1 because they realized that they would be able to claim that the law is unclear and that they will have the freedom to interpret it the way they wished. To the counterfactual about the override clause. I have a counterintuitive suggestion. I think that if there is an override clause, the court will be relieved of the burden of responsibility for the consequences of illegal acts. And it actually would provide the court with more freedom to state what the law is and to say no to power. And let's see the Israeli government responding by denying the court's position. Ultimately, it is the state that relies on the legality of its action as determined by the court. Thank you.
Okay, Dorit. You're on mute, Dorit, you're on mute. You have to unmute.
Okay. First, I think we cannot put all the problems of the Israeli society and the Israeli policy and the governments on the shoulders of a court. There is a limit to the power even of a Supreme Court, especially now we see it. You mentioned in the book, Dave and Yael, that the court takes into consideration the public, the government. I never thought like that, I must say. But we are now in a different situation. We always thought that the judges represent our common values. And now our common values are in danger. Do we have the common values? Is there a danger from internal reasons to the court? And I am afraid there is. We have to protect it very much, as Daniel mentioned. And I don't think that that could, if we have the Knesset will have the power to interfere after court decision. I'm not that optimistic that then the court could decide differently. We have to understand that the court has its limits, and we cannot avoid confronting our problems just by throwing them to the court. The court did a lot. It's never enough. The political situation is very difficult. And the exemption of religious boys from military service are internal problems. The problems of settlements and international law are problems of the state in the international political arena. And here, the court, like a domestic court, and has more restraints, and not everything is open for the court. Yet, as I said, I believe that a lot was done. You know, I must say, I know I'm out of time, but demolition of houses is a terrible problem for the court all the years, and of course, a legal problem. But when you see the government think that they have nothing to do when there is a terror attack, but to show that they can do something, demolish houses. They have to react, the public demands it. So the court took more and more limits on the procedure, on the way, and then just to close one room and all other things as much as possible. The hearing before demolition of houses, this was a big quarrel between me and Prime Minister Rabin, who didn't want to accept it. All those things are very, very complicated. The court, the judges are not aware. They were not on that side. They tried to do their best, and I think they did a lot to protect the protected people in the territories, to protect rights. It's never enough if the system of keeping the territories will not change. Do we want to annex them? Is there a political argument about it? A serious political argument. The court will not solve it. So let's give the court the power to do what they have to do, at least. That's what I can say.
Thank you, Dorit. And now closing statements by Dave and Yael.
Okay, I fundamentally accept what Dorit said, and I 100% accept this court cannot solve the political problems of the state of Israel, and it certainly cannot solve the problem of the occupation. I also accept, and we wrote it in the book, that the court could not really have ruled on the settlement issue, and we stated that if it had ruled, I do not think that it would have had much effect on the settlement policy. So what would have been the point? It would have just undermined the court's legitimacy. Now I accept 100% which Dorit said and what Danielle said. The court today is acting in an extremely hostile atmosphere. The general perception among large parts of the population is that the court is so-called pro-Palestinian, and that it's the branch of some kind of leftist organization. And in Israel today, if you want to delegitimize anybody, all you have to say is that they're a leftist. And so the attempts to delegitimize the court, and those attempts are not by fringe members of the society, but come from the heart of the political echelons. And the court is acting in that thing. So I 100% accept the constraints of the court in the present situation. And in that situation, I personally think that the courageous decision of the court in the regulation case of the SIL 1 case was a major, fantastic decision from that point of view. Now, just in 2 words, what if? What would have happened if the court had said from day one, sorry, we don't have jurisdiction? Well, number one, I don't think that could have lasted. Even if the court would have said it in the 1960s and 1970s, they could not have continued with that, as all the other Israeli institutions were operating in the occupied territories, and yet the court says, no, but we have nothing to do with it. Given the court's general jurisprudence, that was not a possible path for the court. What would have happened on the other hand if it had done it? I referred to this in the first edition, and we didn't mention it in the second edition. Because at the first edition, I was writing at the time of Oslo, where I interpreted Oslo as being awakening in the Israeli elites that the occupation was untenable and that we had to end it. And I thought at the time, well, the court had played a role in legitimizing the occupation in the name of elites, and if it hadn't been there, perhaps they would have reached this realization earlier. I think I was probably wrong in writing that, and so I didn't repeat it in the second edition. So it's very difficult to know what if. There would have been much more lawlessness, much more arbitrariness. Would it have undermined the legitimacy of the occupation in the eyes of some sections of the Israeli population? It's very difficult to know. So once again, thank you all, and now let's have Yaël add what shall I say.
Okay, just
final sentence. Yes.
Yeah, one. Daniel said that the court cannot side, that it's too much to expect the court to side with one party against all the others. And Dorit said that that the role of the court was to protect our common values. And I think in both these statements assume that the discussion is basically internal to Israelis. And I think that's where the problem lies, that the court is in a situation where it needs to rule on disputes between the state and a population that is an enemy population, is a foreigner to at the very least. And this is an anomaly that domestic courts are not intended to contend with and are not equipped to deal with. And I think what we tried to show is the consequences, without arguing causation, but to show the consequences of this anomaly.
Okay, thank you, Yaël. I mean, there is still much to be said. I mean, I feel a bit frustrated that there are so many interesting issues on which we could have spoken hours, such as, the last proposition about individual justice and whether courts can address individual justice with regard to foreign nationals. I think it's fair to say that we do have consensus that we have a very serious problem, and that the problem is not going to go away, and it's probably not going to be resolved by the court. I think there's also a broad consensus that we have a very important book before us that is actually enriching the discussion, that is an extremely valuable resource for anyone who's interested in this topic, be it academic or judges or lawyers or civil society, or just people who are interested to learn more about the history of this very unique interaction between a national court and a situation of belligerent occupation. I want to thank very much the speakers, the 4 discussants, and of course the authors of the book for sharing their time, their energy, their insight with us. Again, thank the Minerva Center, and I want to thank the many hundreds of participants who've joined us. I see there are some news flash that there is maybe some ceasefire later this evening, which is perhaps a very thin sliver of hope in a very dark evening. So I hope for better times. And thank you again for joining us this evening.
Let's hope for better times for all of us. Yes, we need it.
Thanks.
Bye-bye.
Thank you all very much.
Thank you, everyone. Thank you.